Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with Angela Lunn-Logan, and tonight's topic of discussion is guardian ad litems. This is attorney Brad Tengler here with attorney Angela Lunn-Logan. Good evening, Angela.
Good evening, Brad.
Tonight's topic of conversation is guardian ad litems. Angela, what is a guardian ad litem, and can you give a little bit of background about yourself?
I'll start with a background about myself. I have been running my own law firm. The anniversary just came up, so that would be for 6 years.
Congratulations.
Thank you. I do only family law. That's my main area. On occasion, I will do a residential real estate closing.
And just to describe for the audience, what constitutes family law? What are all the different areas?
Of course, divorce. That would include custody, paternity, child support, visitation. Anything that involves abuse and neglect, or what we commonly call DCFS court, is not considered part of family law. Okay. And specifically, you also do a good bit of guardian ad litem work. Yes. And that was, you can be appointed in several different courtrooms. They're in probate, in DCFS, or in abuse and neglect court, or in the family court setting. And I only am appointed to handle guardian ad litem position in the family courtrooms. Okay, and what specifically is a guardian ad litem? A guardian ad litem is an attorney that's appointed to represent the child. Many people will say the attorney for the child. It's a much easier term. We like to shorten guardian ad litem to GAL, the initials. So we often just say the GAL that's appointed. And so in the courtroom, when an attorney is appointed to represent the child, how is that different than other attorneys in the courtroom? Well, the guardian ad litem, or GAL, is solely appointed to handle the best interest of the child, to make recommendations to the court for what they believe the court should be doing. The attorney for the mother has the mother's best interest, and they represent what the mother would want. And the attorney for the father, of course, like the mother, represents what's best for the father. The guardian ad litem is there to look at what's in the best interest of the children. What should happen, regardless of what mother or father want to have happen, what would be best for the children. Okay. So in terms of the process of having a guardian ad litem becoming part of a case, how does that work? The main time a guardian ad litem is appointed is a custody battle. And that would be when either the mother or father has come to court and is saying, I would like to change custody, or the initial determination in a divorce or a paternity case. When a child is born, a paternity case is when children are born to parents that were not married. Now, you said initially in a case, say in a divorce where there's children, do you mean that initially at the outset of a divorce when there's kids, a guardian ad litem will be appointed? How does that work? That is not necessarily. There are many parents who go through divorces that are able to work out who will be the custodial parent. That is not when the parents can agree as to who will have custody, what's going to happen with visitation, and the guardian ad litem is not appointed. It's when both parents want to have custody is the main time that a guardian ad litem is appointed. Their job is to assist the judge in makes a recommendation to the judge as to which parent should have custody, or should there be joint custody. And we can go into different types of custody.
Perhaps explain that to the audience.
There's a misconception that the word joint custody refers to the amount of time a parent has with a child. That is joint physical custody. We also call it primary custody or residential custody. That would be when parents split the children 50-50 or pretty close to that 40-60. When you hear the term just simply joint custody, they're referring to what the parents' legal rights are in making decision-making for the children. Where school do they go to? What non-emergency medical care do they have? What is their religious upbringing? So somebody who has joint custody does not necessarily see their children 50% of the time. They would have to have joint physical or residential or primary custody. Joint custody it refers to just decision-making power.
Okay.
And what we would refer to the judge is, should these parents have joint decision-making power? Should they have joint physical visitation where it would be split 50-50? Should one parent have sole decision-making power? That is what we usually are appointed for.
And these are the things that parents and parties are fighting about, and a guardian ad litem is appointed to help resolve those issues and provide some kind of recommendation to the judge?
Yes.
Okay.
Children aren't interviewed by judges anymore, in a general term. In my career, I've had 3 children in 10 years that have been interviewed, or 3 cases. And the one case, the child was a teenager and just didn't want to have visitation with his father. In another case, we actually had to petition, and it took many, many, many months before the judge would even agree to speak to the children in chambers. We don't want to traumatize children by speaking to judges. That's why they now appoint the guardian ad litem, where we would meet with the child in a less, frightening atmosphere, our office, or sometimes we meet with the children at their home, depending on the situation, and we gather information that the judge doesn't have a chance to gather. We can talk with teachers, we can talk with grandparents, relatives, counselors, principal, neighbors, and gather all this information, and we make a recommendation to the judge as to what kind of custody.
So let's just step back a little bit.
Mm-hmm.
Just to explain to the audience, when a guardian ad litem is appointed, what time during a case is a guardian ad litem appointed? If it's a divorce, is it right at the beginning? Is it in the middle? Is it at the end? When is it?
Well, it depends on what kind of case we're talking. Like I said, the custody battle, first step is somebody files to start a divorce. We'll use the divorce example first. If the parents cannot agree on every aspect of custody and visitation, they go off to mediation. In mediation, that's where you sit down and try and work out with a neutral third party, and it is mandatory that you attend, but agreement is voluntary. So if the parties both want custody and they can't agree as to that.
Who's the neutral third party that hears the parents talk about their children?
That is called a mediator. Mediators have to be appointed by the court. You have to take certain training to be put onto the list.
Are they attorneys?
They can be. They're not necessarily. They just have to a person who completes the necessary training. That person acts in a neutral capacity. It helps the parties try and reach agreements. They do explain what the law is, and they do explain that if they can't reach an agreement, the next step is they have to have a guardian ad litem appointed.
Just to talk a little bit more about the mediation process, is that expensive? Is it reasonably priced? I mean, how does that compare to, say, having a guardian ad litem involved?
It is much, much less expensive than a guardian ad litem. It depends on which mediator is appointed. Each mediator has their own prices. Some attorneys will be at $100 an hour for their mediation services when they're more expensive.
Is that $100 per party or $100?
$100 total.
Total. So
it would be $50 per hour. Now, there are some attorneys who I know bill at their same hourly rate, which would be $175, $185, $200. That's what you would need to talk with your attorney about as to what mediator you're going to select. Certain mediators have certain ways of doing things, and some would work better for certain cases, so that's why you always ask your attorney, would talk with you about selecting a mediator. If you have children, and like I said, unless you agree on every single issues, you're going to be going to mediation. That is the first step. It's a Supreme Court rule, and it's also a local court rule.
How often do people need to go to mediation before a guardian ad litem is appointed?
The standing rule is that unless there's domestic violence involved, which would be physical violence, then every party that cannot reach an agreement in mediation would go. Or, it cannot reach an agreement to enter an order immediately when they appear in court would have to go to mediation.
But how often do they have to? What if they go one time and it doesn't work? Are they going to be required to go back?
It's up to the mediator to determine. What the local rule says is you should attend 3 hours of mediation. Depends on the mediator. I have seen where a mediator has made a party go to all 3 hours. I've seen where the parties have reached a majority of agreements and they can conclude it sooner. I've seen where a mediator realized that the parties were never going to be able to reach an agreement and terminated it 45 minutes in. So it depends on who's appointed and what the dynamics are.
When does mediation get terminated so quickly? That seems quite fast for 45 minutes, people to be able to not talk to each other anymore. Obviously, divorces are emotional, oftentimes with kids, but that does seem rather quickly.
The one situation that I'm aware of, one party got up and said, I'm not going to continue to mediate, is where it's been terminated. Another one, the parties were not acting properly. There was, it became very, very heated. There was a lot of animosity between the parties, and the mediator realized it was never, even if they were less emotional, it would probably not be very productive. I believe it ended up with swear words and name calling, and it was very ugly.
Sure.
Something like you would see on TV.
So mediation doesn't work for some reason, whatever reason it is. What's the next step?
The next step is the mediator fills out a mediator's report. It reports to the judge how many times they met, how long, if mediation is terminated, or they reach an agreement. And obviously, in this case, if it was terminated, then they would decide whether or not a guardian ad litem should be appointed.
Is a guardian ad litem going to be appointed if the mediation breaks down because of minor visitation issues, or is it more that a guardian ad litem is going to be appointed when there's some disagreement between the parties of who should have physical custody?
Generally, it would be if there's physical custody. I have seen cases where the judge needs some assistance because the parties just can't work together to get a visitation schedule worked out.
And in those cases, you've sometimes seen a judge appoint a guardian ad litem?
Yes, and usually there was some other issues, some medical disagreements as to, or some schooling issues. There's usually something else involved. I've also been appointed when custody is not an issue, when one parent wants to restrict the visitation. That would mean having them supervised, having no visitations at all, and those petitions are filed for them to be granted, require extensively something very bad. The statute says seriously endanger the child, either morally, physically, spiritually, emotionally. It is a very high burden, but the judges usually want input at that point. The other time when visitation issues comes in is actually when one parent wants to move to another state. They will sometimes appoint a guardian ad litem to help the judge determine whether or not the child should be removed from that state.
Okay. In the vast majority of cases, am I correct in saying that guardian ad litems are appointed because the parties disagree about who should have custody?
Yes, that would be the majority. There are other circumstances that sometimes lead a judge. We talked about skipping mediation when the judge, and that would be at times when there's domestic violence in the home between the parties. Then they could go directly to a guardian ad litem because for the safety of of one of the parties, they shouldn't be in mediating.
Okay. I keep using the word appoint. I think you've used it as well when we come to a guardian ad litem. Does that mean that the court or that the county is paying for the guardian ad litem? How does that work?
No. The judge does appoint the guardian ad litem. That's how they are added to the case. The judge at that time will then assess how much of the retainer that the guardian ad litem is to be paid. In Winnebago County, the standard is $1,500 for the retainer. The judge then determines how much the mother will pay and how much of that $1,500 the father will pay. The judges, it depends on what judge you're in front of, how that's determined. Frequently, it's determined by the income. If the mother's been a stay-at-home mother for a long time and doesn't have any income, she's going to be paying less than a mother who works, who will set up a payment plan. But generally, many of the guardian ad litems expect the initial retainer to be paid. Then you can work up and set up payment plans. Some guardian ad litems refuse to even speak with the parties and move forward in the case until they've been paid that initial retainer.
Okay. Are there avenues in Winnebago County and Rockford or in Boone County and Belvedere where guardian ad litem work is, paid for by the county or to help poor people with these kinds of situations?
Generally, no. The judge would have to determine that. And I was involved in a case in Ogle County where the judge did say this is going to be, because there was the mental well-being, mental health of the child was involved and she'd been placed in a mental institution on 3 different occasions. So it was very serious, and the parties, I don't believe either parent was working. And the judge there felt it was so serious that they actually appointed and said the county would be reimbursing.
Do any attorneys do guardian ad litem work on a pro bono basis as a contribution to the community?
Some do, but a lot of us, the judge would ask, can you do it at a reduced rate? The judges rarely ask us to do it for no money, but they can ask us to do it on a reduced rate or to take a smaller retainer initially.
Okay. So the judge appoints a guardian ad litem. Generally speaking, almost always the parties need to come up with a significant amount of money, the $1,500. And then what happens? What does the guardian ad litem begin to do?
Well, the initial thing is that we need the paperwork that has been filed in the case. The original order that tells us who is the mom, who is the father, who are the attorneys, what is the retainer, how much is mom to pay, how much is dad to pay, and what is going on in the case. What is pending? Is there an order saying...
What do you mean by what is pending? Just for the audience.
Oh, yes. We use the word pleading, petitions, motions. It's the paperwork that was filed in court. If this is an initial divorce, then it would be, okay, the initial divorce petition. Did one parent file for temporary custody? Is that pending? If it's somebody has come into court and wants to change custody, what was the original order? Who originally had custody? What was the visitation schedule? And who has filed a change? And why do they believe custody should be changed? So all that paperwork is very helpful. Then I read the paperwork. I figure out how many children do these parties have. What are the ages of the children? Because children's needs are very different at different ages. What are the allegations of why one parent should have custody over the other? Or is it just initially we need to figure out custody? So we have to determine quite a few different things. I always like to, once I get all that paperwork, meet with the mom and the dad separately and learn the history. Tell me about, your children. Why do you think you should have custody? And get some initial background and start talking to both the parents. Who do they want me to talk to? Should we talk to, there's a teacher, a counselor, grandparents, neighbors.
Who do you usually speak to first?
It depends on my schedule and the schedule of the mom and the dad. I don't specifically always meet with the mom or the dad first, but I always meet with the parents because I don't always meet with the children, but I always meet with them second.
Why don't you say you don't always meet with the kids?
No, it depends on the age of the children. If there's one child who's 3 years old, that may not be, or even smaller, then it may not be as important. A 3-year-old can't really convey a lot of what's going on in their life, whereas a 5-year-old can give you more information. A 12-year-old can give you a lot of information. So it depends on the age of the child or children. What are the allegations going on? What kind of information can the children give me? I try and keep children from being traumatized in any possible manner.
Where do you usually meet with the kids, if you meet with them? At the home, at your office?
Well, my office is in my home. So I think it's a much better environment for children to come to an actual house. So I meet with them in my living room, or I do have an office. I do have my dining, what people would call a dining room, is where my office really is, and then I have a separate bedroom that I use as an office that I can meet with the children.
Do you ever go to their house to meet with the children?
Yes. Recently, I represent a 4-year-old and a 5-year-old girls. And there was domestic violence in the home, and from what the testimony was presented by the mother, I thought the girls would feel much better if they actually were at their house. And I will make home visits is one of the things that sometimes we do.
When and why would you conduct a home visit?
When I go to the home would be, in this case, I thought the girls might feel much more comfortable and be more open if they're in their own home. I had a case where one of the parents was concerned about the home environment of the child, and so then I would go and investigate to see what is the environment. Sometimes it's cleanliness issues. Sometimes it's there's other things going on in the home.
After you meet with the parents, and then, as you said, sometimes the children, there are other entities, other people that you meet with. Who are those other people? And first of all, who are those other people?
Those can be teachers, relatives. One of the things that's very important, if there is step-parents, or a mom has a new boyfriend, dad has a new girlfriend, or new wife, like I said, it depends on what kind of case you're at. And if the parties were never married, they may already have other, another boyfriend or girlfriend in their life, and it's very important to meet those individuals, because especially if they live together, that's, who else lives in the house with these children? Do we have a grandparent that lives there? Anyone else in the home is very important to interview. Counselors, very, very important.
You mentioned new girlfriend, new boyfriend.
Yes.
I think one pressing question that a lot of people have when they're going through a divorce, or there's some kind of change in custody that's potential, is when, if ever, is it appropriate to have a new girlfriend or boyfriend around the kids? And does it affect custody at all? Does it affect how guardian litem thinks about custody?
Every case, we look at every case individually. Some cases, they've never been married, and they've been getting along, say, for 3 years. They've been separated, they've been working out custody. I see this frequently. There may be somebody else, in that parent's life that can happen. If it's a divorce and let's say there was an affair, and this person moved out and moved directly into that person's home, that may be very stressful on the children to go be with, just to pick one, to be with that parent, say the dad, and the new girlfriend, when the children know that there may be some animosity that this dad left mom to be with this woman. So it depends on what kind of case you're looking at. Is there allegations? Is the new person a registering sex offender? That's a big problem. Do they have a criminal background? Are they the most loving elementary school teacher? So it does depend on every case is very specific, but it can influence.
Generally, is there a time period in which a parent should or should not introduce their children to a new paramour?
I believe all of us guardian ad litems have different opinions on that.
What's your opinion?
I'll tell you, my opinion had been that, you should see this relationship's going to work out. You shouldn't bring them home and meet the kids on the first date. I stand by that. I did recently have someone who said, I don't want to develop a relationship with someone if my children don't like them. That changed my opinion significantly, because you're right. If the girl you're dating can't get along with your children, then why would you want to continue the dating? But you'd hate to see them put in 2 years and then introduce, or 6 months. So I do see, it depends on how responsible the parent is and how the parent does this. if there was an affair and, then they're moving in, that the children are going to have a lot more issues in dealing with than, okay, mom and dad have been separated going through a divorce for a year. Now we have somebody, or, maybe they've been divorced for 2 years. So it depends on how are the children.
In Illinois, can a party have a petition granted to bar a new, girlfriend or boyfriend being around the kids?
Well,
a lot of people get upset about this kind of stuff.
You can file anything you want. The question is, will it be granted?
Granted.
People will file them. It doesn't necessarily mean just because someone's filed something. It depends. I had a case where we discovered after the fact that the boyfriend had been convicted of a sex crime and had been a registering sex offender. That is something that that's very significant. The court doesn't like to restrict people's visitation, and that includes restricting who the children can see. If that person's a registering sex offender, you have a much better likelihood that child may not be able to be around them. They may have probation issues that don't allow them to be around children to begin with. So there may be some crimes that they're committing by being around these children. Now, say it's a normal person, no criminal history.
Yeah,
they just don't like it.
Someone they've been dating for 2 weeks. They're not divorced yet. They've only been separated for, say, 2 months.
The court is very reluctant, unless the children are going to be seriously endangered, to put those restrictions. No criminal history, just as a new girlfriend.
Is that the standard, serious endangerment?
Yes.
Okay.
That's what you should be looking at. I know it's not pleasant that they introduce somebody new, and is that in the children's best interest? Probably not.
Do you think it affects our judges' perspective of who should get custody if a father or mother is introducing a new boyfriend or girlfriend around the kids at an early stage in the relationship?
I believe everything you do can come into play in a custody battle. I would advise my clients not to move in with somebody very quickly after they're separated, especially if there was some kind of an affair going on. That's going to look not so good, especially if the children decide they don't want to be around this man that you've had an affair with, or woman, and the children are distraught by this. Then it's going to be not in the children's best interest to put them through that.
Just for the record, we are not in the studio this evening. We're actually at Capri. So if you hear Frank Sinatra, which both Angela and I are smiling about, it's due to being in an Italian restaurant. So back to the issue, or was there anything else you wanted to say about paramours being around kids and affecting your perspective as a guardian ad litem?
I think the advice I give to my clients when we have a guardian ad litem appointed that's not me is to think about how would the judge view your actions. What would the judge say? And that way, if you think this might look skeptical to a judge or a judge may not like it, then don't do it.
Yeah, I always, just as a divorce attorney, I don't do a ton of guardian ad litem work. I tell my clients, judges are humans too. Think about you being in their position, making a decision about visitation or custody. How would you handle it if you knew X, Y, and Z? And then think about how you might want to change or keep going with the same kind of behavior.
Exactly, and that's what I try to explain to some parents who may not be doing something in the children's best interest. Look and see how this is affecting your children. Some people get very emotional and forget that their children are seeing everything. I like to call them sponges. They hear and see everything. If they're in the house and you're on the phone talking to somebody bad about the other parent, those kids more than likely will hear it. Try and avoid doing those things. Think of all your actions. How will the judge see this, and how will this affect my children?
Would you like anything else to drink, or are you okay?
Great. Thank you.
What did you tell them they're at Capri?
Angela, I heard you use the word best interest of the children. Is that the standard that a guardian ad litem uses to make determinations about who should have custody and who should not?
Yes, you're going to hear us use a lot of catchphrases. The one you've heard me talk about earlier was serious endangerment. And you're going to hear attorneys using that phrase, a judge using that phrase. The other phrase we use is best interest.
Well, and just as a side note, where do these catchphrases come from?
They come from the statutes. Section 602 of the Illinois Marriage and Dissolution of Marriage Act is entitled Best Interest, and it sets forth what us guardian ad litem look at making determinations. There is a lot of case, you're going to hear the word case law. What case law is it's cases that have gone up on appeal from a trial court, which would be like here in Winnebago County. They then get appealed. Then the judges make rulings and say, okay, yes, this case with these facts applied was right or it was wrong. And then we will use the terms, there's case law. So that's the law that's come down from the case, saying these are the specific facts that fit into these issues. You should go this way or that way. So you're going to hear me, and I tell parents often when they come in, I'll pull the statute out and say, this is Section 602. This is what I use. It's a map for me. I will go through each section and look at it. One of the sections is, what does the parent want? So, does mom want custody? Does dad want custody? Well, generally, my situation's always yes. Both parents want custody. The next factor is, what does a child want? That is a factor. Children in Illinois do not get to determine which parent they live with.
I hear people say all the time, when can my kids make a determination of who they want to live with, or if I'm talking to the kids, they might think that they have the ability to determine who they live with. Is that true? How does that work?
That is not true. A child, people will say, at 12, at 13, I get calls all the time. If my child's 14, can they decide? No, the child cannot decide.
What if the child absolutely, entirely detests and hates their father? And they don't want to go and see their father. And I had that case where I actually represented the mom, and the child did not want to go. The backstory is the father had an affair, and then went and lived with this woman, and the 14-year-old boy was very angry. In that case, because it was just about visitation, and it was a judge who had been a judge for a very, very, very long time, and realized the expense for the parties would not be worth to have a guardian ad litem appointed. So he met with the boy, and he was old enough. He was 14, and he was a very angry boy. So the judge said, I'm not going to make him go see his father. He recommended counseling, but it's understandable that a child, when he sees the father have the affair, there may be some anger. The father then agreed not to pursue that. So in that particular case, the judge considered it to be such a significant factor?
Yes, the affair.
The affair was the factor, or the hatred of the boy for his father?
The affair's effect on the boy, resulting in his hatred. That the judge understood it, that it would be very detrimental mentally to the child to have to go.
So are you implying or not, if someone has an affair, is it going to make a determination of who has custody?
It could, depending on what's going on with these things. But no, just saying an affair will determine custody, no. If somebody has an affair, they're not going to lose custody, necessarily. It's not, you had an affair, you're not allowed custody. That's not one of the factors. One of the factors is, what is the children's opinion? Who does the child, no, we never directly ask the child, which parent do you want to live with? Some kids will come and tell you, I want to live with this parent. But the reason that children don't get to determine that is because children don't act in their best interest. Of course, when you first become an attorney, you'll see this. You go, this is ridiculous. Children should be able to do this. But the longer I practice, the more I realize it's a very good situation. Some parents will bribe children and tell them how great life will be if they come live with them. Sometimes they will threaten children. How bad life will be if you don't, or if it won't be good for your sibling, or how much money this is you're going to cost your mom. Lots of different things, or your dad can be threatened. I see bribing more frequently than I see threats.
So how does a parent bribe their child about custody?
I've seen them say how much more gifts they were going to get, how much they're going to have their own bedroom, they're going to be able to do this and be able to do that. And oddly enough, in that case, the child told the judge and let the judge, let everybody know the child wanted to live there. It was a factor. The judge, looked at the factor and some other issues, agreed to change custody so the child could go live there, and the child immediately did not get the things they were promised.
Why didn't the judge see through that?
There were some other schooling issues in that particular case. The child had just got diagnosed with ADD and had been in summer school for 2 years. So the judge thought maybe a change and the other parent might be able to do better. And while we were in between 2 court dates, the child got diagnosed with the ADD and got put onto some medicine. So after, it was a factor more of the failing school for 2 years.
So you have listed the desires of the parents as a factor, the desires of the child as a factor. Are there any other factors which help a guardian ad litem determine the best interest of a child based on the statute, based on the Illinois Marriage and Dissolution of Marriage Act?
We are to look at the environment. Is there any domestic violence in the home? The statute then, of course, cites another statute that talks about domestic violence and all those definitions. Is there, any environmental issues, in the home, aside from domestic violence, that are going on? So we look at, does either parent have any mental issues, any drug problems, any alcohol issues that may influence, mental health issues? Does one parent have depression? Does one parent schizophrenic?
What about a parent that is constantly talking bad about the other parent in front of the child? How does that weigh in?
Well, that was more from the case law where it's detrimental to the child's well-being. If you try and interfere with the relationship between the other parent and the child, you can either not be granted custody or have custody taken away. Illinois views it as best for the child to have as much interaction with both parents, and they don't want to restrict visitation. Like I said, to seriously endanger the child. So they want both parents to be involved. And so you're going to have to show there's some, serious reasons the child shouldn't be involved, but maybe a parent who has some mental health issues can't parent as well, or needs to have certain restrictions. Time-wise, or not as, may not be the best parent for the child because they have some issues. Maybe they have a drinking problem.
Yeah, I want to go back to something about parents talking bad about the
Yes.
other parent. Okay, I've seen situations like this. You've got one parent that talks so badly about the other parent for such a long period of time that it so influences the child that the relationship of that child with the other parent almost completely breaks down. How does a guardian ad litem weed through that? Because obviously the other parent, well, I'll stop there, but how does a guardian ad litem weed through that?
Well, generally, if you meet with a child, you meet with a parent, and if one child is basically mimicking, echoing everything that parent says, then when you hear the same words, he's a worthless bum. And if that child uses that same, my dad's a worthless bum, then you start to wonder, why are they using the same words?
So what's your remedy, though? I mean, that's my question. Because
first you got to figure it out. That may not be the easy part. When you see that, then you have to try, because the last thing you want is the children to be alienated from the other parent.
But what if they already are alienated?
Then what you want to do is, you can't just force this child who's, I don't want to say that we're brainwashed, but, been conditioned to think dad's a worthless bum. Then you need to get the dad and that child into counseling. Something we like to call reunification counseling, to try and work on their relationship so the child can see dad's not a worthless bum.
Are there therapists here in Winnebago County, in Boone County, that specifically deal with reunification counseling?
I don't know if they say we specialize in that, but I do know that there are counselors. One was in a case where I'm guardian ad litem that's been involved, and one was in Crystal Lake. But I know Elise Cadigan, I'm sure she's very well renowned here. So I would call and ask and say, this is what we're trying to look for. And there are Rosecrans has made a recommendation on a case where we're needing the reunification, because that same thing is going on in a case that I'm involved in, where the mother has, the child is actually echoing the mother's words and saying that these things are going on. And the dad's, I don't think that we use the word worthless bum, but I think worthless wasn't part of one of the words they used. And so you need to work on reunification, because you just can't take a child who's thinking that and been kind of programmed to think that and throw them in with dad, because that's going to wreak havoc on dad and the child's life. The school is not going to go well for the child. You need to work on that relationship and then see, as a mother or father's actions,
so
change custody.
Here's another example along these lines. Dad has filed a petition for modification in custody. Okay?
Mm-hmm. Yep.
But mom has alienated the child from the dad by, calling him all kinds of names, and the child is under these impressions about his father, which are not true. Your initial recommendation, it seems to me what you're saying, is some kind of reunification counseling.
Yes.
With a therapist such as, Elise Cadigan or other people in town who do this kind of stuff. They go to counseling, and they begin. I would imagine that's a long process.
It can be.
What's been your experience of how long that is?
Well, it depends on what's going on. In the one case, we are just in the beginning. We're just getting the counseling initiated. The child was supposed to have been in counseling already, and mom has refused to take the child to the counseling.
Imagine that.
Yeah, and that was one of the issues. And what's been going on is that the longer the case has been pending, the more desperate mothers become to make dad look like, I guess we'll use the word, worthless bum. So it is getting drawn farther, it's getting more extreme, the things that mom is doing and instructing the child to do.
Well, isn't the judge at some point going to push for his petition, for the father's petition to modify custody to be heard?
Well, the guardian ad litem, in this case, believes that it's in the best interest to reunify dad and child before pushing the petition. Because if you push the petition right now, although the judge can look at it, the judge is going to see this daughter who doesn't want to go with dad. And that's not going to be in the best interest of the child to take her at this angry stage and put her and transplant her to dad. It's going to be bad for everybody. Unfortunately, it's hard to see sometimes as a parent that sometimes waiting is what's going to be in your best interest. It's like, if you have an angry 11, 12, 13-year-old girl, it's like putting an angry badger in your house. Not the best thing. They can, be...
And so, 13, 14-year-old girl you refer to as an angry badger who has been alienated from her father. What is an angry 13 or 14-year-old boy?
Well, I guess they're probably both going to be badgers. I mean, we can say Tasmanian devil. But it's not going to be good for anyone involved, and the change in custody isn't going to work. And it's going to come across as a punishment to the child when the child is a victim of what the other parent is doing. And we want to make that child better and work on that. And I know it's very hard for a parent to wait and be patient when this is going on, but many times it's what I advise now the GAL, the parties when I'm GAL, and my clients. Because sometimes it takes a while. A parent can do a good job of cleaning up their act and looking good for a while, but they may not be able to do that for an extended period of time. And that's in this case where the mom is just escalating what's going on. It's becoming more and more obvious that this alienation is occurring. And now we need to get the counseling going. Now we need to work on getting back with dad. And will the GAL in that case tell that we're going to be moving, custody? I think that might be the route, because this has been very detrimental to the child. She's been forced to lie.
Sure.
And we don't want to teach the child that. And it may be a very lengthy process. We're just at the beginning in this case of seeing what's going to happen.
So, I've heard you list a number of different factors. What the parents want, what the kids want, whether or not there's been any alienation that's going on, and how to remedy that. Are there any other factors that the statute requires a guardian ad litem to take into consideration?
Well, I think I'd said that the alcohol use, drug use,
Sure.
any kind of mental issues, the physical abuse is a very significant factor to look at. And then there's, every case has its own little quirks, little issues that may come up that you're not going to see in every case. Alienation isn't something we see in every case. It's something that just occasionally comes up. Is there is either of them registering sex offender? Are they dating somebody who's a
Sure.
registering sex offender? Those issues come up rarely.
Sure.
I've had one case in my career.
So you take into account all these factors, you talk to all the relevant people and parties, and then you form a recommendation. Is that right?
Yes, I tell the judge who I think should have custody. Should it be sole or joint legal custody? And, should they have joint physical custody, which the statute requires to say the parents, it's unusual for us to grant joint physical custody because the parents have to be able to
Some
work
judges
together.
in our counties will not even do that, correct? As a rule.
They are very, very reluctant, and they want to see the parties be able to work together. They have to have a visitation split that's 50-50 or 60-40. And that's what the statute tells this judge. It should be an extraordinary exception where parents have joint physical custody.
So when you make this recommendation to the judge, is it binding on the parties? Do the parties have to abide by the recommendation of the guardian ad litem, or do they have any other recourse to continue their custody petition?
When the initial recommendation comes out, it can be either in a written form where you can read through it. That, of course, costs people lots of money because sometimes these are 15, 20, 30 pages. That's a lot of work to be paying somebody to write out. We often, and I try and talk to the parties and their attorneys and ask, can I just make an oral recommendation? I can give all the reasonings why. Sometimes you can do a short letter summarizing. I've sent them in emails explaining to try and keep the costs down for the parties. At that point, they should discuss with their attorneys. It's a recommendation. It's not a ruling that the judge has made. It's just a recommendation to the judge. It depends on which judge you're in front of, what happens then. Sometimes the judge will say, we need to have what we would call a settlement conference. An attempt to settle would be like a pretrial conference. If the parties really don't agree, they can go to hearing, which again is going to cost a lot of money.
What do you mean by go to hearing? What does that mean?
A trial. I guess the layperson would use the word trial, just like you watch on Law and Order, where you have witnesses.
Jury trial?
There's no jury trials in family court. But it would be just in front of a judge. You would call witnesses. Now, the guardian ad litem is in a very strange position. We can call witnesses to come testify, to back up the information we provided. We get to cross-examine witnesses. The guardian ad litem then is called to testify about this
custody battle, right?
Yes. And what were your recommendations? Who did you speak with? Why do you believe this information? Did you know this at the time? In my experience as a guardian ad litem, I've always sat in it. We've gone all the way to trial, or what we could call a hearing. Then the last person who was called would be me, the guardian ad litem, because I can learn new information. If witnesses get on the stand and say something completely different in front of the judge than they did to me, then I have the ability to cross-examine them. I learn new information. So I can, at the very end, would go to the judge, yes, this is some new information has changed my recommendation, or I still have the same exact recommendation. And then both attorney for mom and dad get to question me. They get to cross-examine me. And if I have ruled against, said that, let's say, dad should have custody and mom shouldn't, then mom's attorney can, try and discredit me and say that my opinions doesn't add up with all the evidence. Just like you could if you were similar to a criminal trial, you don't think the state has enough evidence to convict somebody.
Well, I think you have brought us through pretty much the whole process, and I really appreciate you being here this evening, and I'm sure folks who are listening do as well, because this is a new process for them, and a lot of people, as a divorce attorney myself, they have no idea what a guardian ad litem is, and the process and the expense for it and all those kinds of things. People are not aware. Any, Angela, last words of advice or summary words about how people should deal with guardian ad litems, approach guardian ad litems if they find themselves going through a custody situation?
Depending on who your judge is, sometimes the guardian ad litem's report is the most important thing in determining custody. I've had a judge say, unless some completely different evidence is presented at trial, it's very unlikely, the judge said, that I would not follow the recommendation of the guardian ad litem. So you want to keep the guardian ad litem happy, because they're going to, and if they ask you for information, provide it. If they tell you, I have some concerns, listen, ask, say, well, what would you do in this situation? If you have an 11-year-old angry daughter, they're not the easiest to deal with. You can say, what should I be doing? The guardian ad litem is very important in a custody battle. So I would recommend making sure that Gesundheit.
Thank you.
If they ask you for information, comply with them. They're very, very important during this process because the judges, like I said, are likely to follow that recommendation. And also keep in mind that you're going to be having your own attorney, and the expense can be very large. You're going to be already paying for part of a $1,500 retainer here in Winnebago, and then if you ask them to talk to 20 people, you're paying for that person to talk to 20 different people. So you want to keep, whittle down who's the most important witness that you should speak with, and try and understand that the more you ask them to do, the more you're paying for. So you have your own attorney plus a portion of them. So keep that in mind as to how you want to go forward with your custody battle.
Well, thanks again, Angela, for being here this evening and talking about guardian ad litem work. I appreciate it. I'm sure our audience does as well.
I appreciate you asking me.
Absolutely. And I'm sure we'll have you back as well.
Oh, I would appreciate being back.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.